Welcome to Shenkman Education. My name is Marty Shenkman. The topic of this video clip is, what is a fiduciary? A fiduciary, fiduciaries are named in all estate plans. The executor or personal administrator under your will is a fiduciary. The trustee under all your trusts is a fiduciary. The agent under your powers of attorney for financial matters is a fiduciary. The agent under your healthcare proxy is a fiduciary. What is a fiduciary? A fiduciary is a position of trust. You, if you're naming these people, are putting your trust in them to do what is expected and what is right for the people that they're serving. For an estate or for a trust, it's a beneficiary. For a power of attorney, it is really the principal. It may also include donees of a gift power under the power of attorney. For a healthcare agent, it's you as the principal signing the document. What is a fiduciary relationship is important to understand, and many people don't understand the importance and the potential legal liability if they don't carry out their role. So if you're naming a professional like an attorney, a trust company, as a trustee or an executor, they should understand what the implications of serving as a fiduciary are. But oftentimes people name family, friends, and others, and when those people are named, they may not really understand the implications and the importance of the act that they're serving in, the role they're serving in. So let's go through a few of the concepts, legal doctrines that affect a fiduciary. Very important if you're going to serve in this role to understand it. So again, fiduciary means a position of trust, and you have to act accordingly. And you need to take it seriously, because if you don't fulfill your duties and you violate the trust or any of the principles we're going to talk about, you could face personal liability. So when you're in a position of trust, a fiduciary, like an executor, we'll just call it executor, you are owing to the beneficiaries a number of duties. You owe them the duty of care. That obligates the fiduciary to act, the executor to act with the same level of care as a reasonable and prudent person. You can't just do what you think or what you want. You have to conduct your activities as the executor or trustee as a reasonable and prudent person would do. And that's an objective test that a court will apply if you don't do it. You have a duty of loyalty. You owe loyalty to the beneficiaries of that estate or trust, and you have to act in a way that it's in accordance with that duty of loyalty. You can't personally benefit other than a trustee or executor commissioner fee. You can't transact business with the trust, and you need to be very careful. Even if you buy an asset from the trust at fair value, does that violate potentially the duty of loyalty to the beneficiaries? You need to be very careful with any interrelated party transactions with the trust or estate that you're a fiduciary for. You owe a duty of good faith. You have to act in an appropriate manner that shows your conduct is conscious in a good faith manner of the needs of the beneficiaries. You have to deal fairly. And again, that's going to be interpreted based on the circumstances, but anything you do personally, such as buy something, sell something to the trust or estate, could be suspect. You have a duty of impartiality, which requires you to act in the best interest of the beneficiaries. Now, the impartiality also can be quite complicated when you have multiple beneficiaries. It's very common for an estate to name multiple children or nieces, nephews, or others. It's very common for a trust to have many kids or other named beneficiaries. When you have multiple beneficiaries, you can't show favoritism to one of them. So let's say there's 3 beneficiaries, one wants to buy a house. You have to be very conscious, what are you doing for the other 2? Many institutional fiduciaries are often reluctant to make a distribution or provide particular benefit to one beneficiary if they don't do it for the others. So just to summarize, serving as a fiduciary, trustee, executor, and the other roles that we talked about is really very important. And it's very important for your own protection. It's very important because you're carrying out the wishes of the person who appointed you, and you almost always have very significant responsibilities for the well-being of the beneficiaries. When a family member, business partner, or other person is named, make sure they hire legal counsel that will help apprise them of these concepts, and there's others. If it's not done, most lay people simply don't understand the nuances and the import of all this. So again, a fiduciary is critical and common, a common appointment in all estate plans. Be very mindful when you appoint a fiduciary that they should understand their role and the responsibilities they have. Thank you for joining me, and please keep in mind that all the information on the video clip is for educational purposes only. Don't take any action without appropriate professional guidance. For more information, visit www.shenkmaneducation.com. Thank you.